Officer James Blassingame has been a veteran of the force for 17 years and Sidney Himby for 11 years. Both say former President Trump is to blame for their suffering as a result of the attack that day. Now they want the court to find him responsible. The lawsuit filed yesterday includes tweets from former President Trump dating back to November, which they say outline how he, quote, inflamed, encouraged, incited, and directed the violent mob that stormed the Capitol to stop the steal. In the months following the election, 5 people died in that attack.
In effect, they argue that his rhetoric leading up to January the 6th and his speeches on January the 6th encouraged and incited the individuals who attacked them to use violence against these 2 officers.
You better run, cops!
The lawsuit describes the fear the 2 officers felt inside.
Pay attention to this one, not just because it connects directly to the officers in that opening clip. Blassingame and Hemby, who filed their lawsuit saying Trump inflamed, encouraged, incited, and directed the mob that attacked them. Their case depends on records. Documented communications, preserved evidence of what was said, when and by whom. That is the thread from the opening clip to the story I am about to tell you, and not just because it is the most analytically underreported development of the entire April 2026 accountability moment, not because it's the loudest story right now, because it might be the most consequential. On April 7th, 2026, the same day 70-plus members of Congress called for Trump's removal, a lawsuit landed that almost nobody is talking about the right way. The American Historical Association, chartered by Congress, filed for an emergency injunction against a memo quietly issued by Trump's own Office of Legal Counsel. The memo claims that presidential records are personal property, that presidents can withhold them or destroy them, and that the Presidential Records Act, the law passed specifically after Watergate to prevent exactly this, doesn't actually apply. Think about what that means for 1 second. Every document from this presidency, every email, every record of every decision, every communication that investigators, Congress, or historians would need to understand what happened during Trump's second term. All of it, if this memo stands, potentially gone. And the president's own lawyers saying that's fine, legal, is right. The historians are fighting back. And the reason this matters right now, not in 5 years right now, is that records are the foundation of every single accountability investigation currently open on this administration.
They were outnumbered by the pro-Trump mob. It also outlines the officer's physical injuries. Officer Himby says he was crushed against the doors of the Capitol, was sprayed with chemicals, and bled from the face. Officer Blassingame says he was slammed against a stone column, causing injuries to his head and back, and says he suffered significant emotional damage as well. But Aziz Huq, law professor at the University of Chicago, says the case faces an uphill battle because of a 1982 Supreme Court ruling that gives a president immunity if his words are spoken as a part of his role.
Destroy the records and you don't just erase history. You erase the evidence. That's the story. Let me start where you need to start, with what actually happened at Mar-a-Lago, because this isn't theoretical. We have already seen what Trump does with documents he considers his. We watched it happen in real time. After his first term, Trump took boxes of materials to his Florida resort. Classified documents about nuclear programs, intelligence sources, military capabilities, documents that legally belong to the government, to the National Archives, to the American people. And when the National Archives asked for them back, Trump refused. He said they were his. The FBI had to raid Mar-a-Lago to get them. Jack Smith investigated. His memos, cited in this new AHA lawsuit, found that Trump kept the documents for a business interest motive, not national security, not a dispute about classification, a personal benefit calculation. Valuable documents kept because they were valuable to him, and prosecutors charged him with crimes until Trump won the 2024 election and everything changed. Now here's the part that should stop you cold. Trump is back in office. And instead of accepting that what he did was illegal, instead of following the rules this time, he is trying to make it legal. The OLC memo is the legal architecture to retroactively justify the Mar-a-Lago behavior and to authorize the same behavior going forward. What was a crime is being reframed as a right. What prosecutors called obstruction is being rewritten as personal property. That is what the American Historical Association is suing to stop. Here's the thing about the Presidential Records Act that puts Trump's memo in direct legal conflict with 50 years of established law. The act was passed in 1978, 1 year after Nixon versus GSA, a Supreme Court case that matters enormously here. After Watergate, Nixon tried to control his presidential records. He argued separation of powers gave him the right to decide what happened to his own documents. The Supreme Court said no, flatly. Presidential records are created using government resources. They document government actions. They belong to the American people. Congress codified that principle into the Presidential Records Act the following year. Every president since has operated under it. Records have to be preserved. They transfer to the National Archives when the president leaves. The default is transparency, not secrecy. Trump's OLC memo is making the same argument Nixon made to the Supreme Court in 1977, and the Supreme Court already rejected it. The historians are not inventing a novel legal theory. They are pointing to existing Supreme Court precedent and saying this exact argument was already lost 50 years ago. The court already decided this, and Trump's own lawyers are making the same losing argument dressed up in new language, hoping courts either don't notice or have changed their minds. That is the legal posture of the OLC memo. Not a sophisticated new constitutional theory, a recycled argument that already failed at the highest level. Now, let me tell you why April 7th matters as the specific date this lawsuit was filed. Same day, April 7th, 2026, 70 plus members of Congress call for Trump's removal over the Civilization Will Die Tonight post. And the American Historical Association files for an emergency injunction against the OLC records memo. That is not a coincidence in terms of stakes. It is a convergence in terms of what each development requires. An impeachment investigation needs documents. It needs records of what Trump knew about the Iran operation and when, what advice he received, what he was told about civilian casualties, what decisions he made and who was in the room. Without those records, the impeachment investigation is arguing from inference and public statements. With those records, it is building an evidentiary case. The same is true for the war powers litigation. The same is true for the voting rights lawsuit from 23 states filed April 2nd. The same is true for the ongoing January 6th civil cases. The same is true for the Epstein accountability threads this series has documented throughout the second term. Every open accountability investigation is at its foundation dependent on documents existing. Presidential records are the evidentiary backbone of the entire accountability infrastructure. Trump's OLC memo, if it stands, removes that backbone. Not from one investigation, from all of them simultaneously. You do not need to find the smoking gun if you can legally destroy the room where the smoking gun would be kept. That is a specific danger of April 7th that got lost in the noise of the removal calls. Let me explain the self-authorization problem, because this is the most analytically alarming dimension of the OLC memo. The Office of Legal Counsel is part of the Justice Department. The Justice Department is part of the executive branch. The President of the United States is the head of the executive branch. So the sequence is Trump's executive branch issues a memo saying Trump's conduct regarding records is legal. Trump then points to that memo as legal authority for his conduct. The president's own subordinates declaring the president's own behavior legal, and then using that declaration as the legal shield. This is the same mechanism this series documented in prior commentary on the APA violation pattern. An administration that treats procedural requirements as optional obstacles, moves fast, and accepts litigation as the cost of governing. But the records memo goes further. It is not just ignoring a procedural requirement. It is attempting to retroactively authorize conduct that was already found criminal and to establish legal cover for future conduct. The courts have already rejected this mechanism when it appeared in other forms. The DC Circuit found agency firings illegal. SCOTUS found IAPA tariff authority exceeded constitutional limits. The Massachusetts court found the wind energy order arbitrary and capricious for lack of reasoned agency analysis. All of those rulings, this series documented the two-thirds APA violation pattern throughout the second term, applied the same basic principle. The executive branch cannot simply declare its own conduct legal and proceed. Independent judicial review exists precisely to prevent that. The AHA lawsuit is asking courts to apply the same principle to the records memo. You cannot authorize your own behavior by having your own Justice Department write a memo saying it is authorized. Here is the behavioral signal the document correctly identifies, and it is analytically available regardless of what the memo specifically says. The document puts it directly. Innocent people do not destroy evidence. They welcome investigations. They cooperate. They turn over records. The behavioral pattern surrounding the records question: Trump took classified documents from the White House. He refused to return them when asked. He claimed they were his. He kept them at a resort frequented by foreign nationals. He required an FBI raid to retrieve them. He was charged with crimes. He won the election. He returned to office. And then, instead of following the rules, his Justice Department issued a memo claiming the behavior that produced criminal charges was actually legal. That behavioral sequence is the consciousness of guilt signal. not as a legal determination, as an analytically available behavioral inference. When someone goes to this much institutional effort to create legal cover for conduct that was previously found criminal, the behavioral inference about why they are doing it is available. The document contents may be unknown. The behavioral pattern surrounding them is documented. Let me walk through what the AHA lawsuit is specifically asking for and what the outcome of each path means. The American Historical Association is asking for an emergency injunction, a court order blocking the OLC memo immediately, before records can be destroyed. If the injunction is granted, the memo is stayed. Records cannot be destroyed under its authority. The evidentiary backbone of the accountability investigations remains intact. All of the open proceedings, impeachment, war powers, voting rights, January 6th civil cases, Epstein oversight, continue to have access to the documentary record they require. If the injunction is denied, the memo stands while litigation continues. Records can potentially be destroyed during the gap. Evidence that would have been available to investigators, Congress, and historians may no longer exist when the litigation ultimately resolves. Even if courts eventually strike down the memo, which the Nixon versus GSA precedent suggests is likely, the destroyed records do not come back. The emergency character of the injunction request is analytically significant. The AHA is not seeking to litigate this slowly. They are saying the damage occurs during the delay. If this is not stopped now, the harm is not reversible. That urgency is the specific institutional signal that the historians are treating this as a real and immediate threat rather than a theoretical legal dispute about archival principles. Here's the three-level significance that most coverage of this lawsuit is flattening. Level 1, historical accountability. Future generations need records to understand this presidency. That is real, but feels abstract. It is not why the AHA filed for an emergency injunction. Level 2, current institutional accountability. Congress needs records for the impeachment investigation. Prosecutors need records for ongoing cases. The 23 states need records for the voting rights lawsuit. The January 6th civil plaintiffs need records. All of these are live proceedings that require documents right now. This is the emergency level, the level that explains the injunction timing. Level 3, the structural precedent. If this memo stands, if a president's own OLC can declare presidential records to be personal property and the courts accept it, every future president of both parties inherits that precedent, not just Trump. The Nixon versus GSA principle that records belong to the American people gets eroded. The Presidential Records Act's transparency default gets reversed. The post-Watergate accountability architecture gets dismantled through a memo. Level 2 is what drives the emergency injunction. Level 3 is what makes the outcome historically significant beyond any individual presidency. The document is focused primarily on level 1 and 2. Level 3 is the most analytically significant available dimension, and it connects to this series' ongoing documentation of how second-term governance choices are producing permanent institutional consequences beyond any individual case. Let me tell you why the American Historical Association specifically has legal standing that makes this lawsuit harder to dismiss as partisan opposition. The AHA is chartered by Congress. That means Congress itself created and authorized the organization for the specific purpose of preserving and promoting historical scholarship, including the preservation of records. When an organization chartered by Congress to preserve historical records sues to protect historical records, it is not a political organization making a political argument. It is a congressionally authorized institution fulfilling its congressionally mandated purpose. The standing question in who has the legal right to challenge this memo is often where executive branch legal defenses begin. The government argues that the challenger does not have the right to bring the case, regardless of its merits. Against an organization chartered by Congress for record preservation, that standing argument is significantly harder to sustain. The AHA's standing does not guarantee they win on the merits, but it substantially reduces the procedural obstacles to getting a court to hear the case. And given the Nixon versus GSA precedent on the merits, getting the case heard is most of what matters. Here is where this goes. The emergency injunction request means a court will have to respond quickly. Either it is granted or it is denied. Both outcomes produce immediate institutional consequences. If granted, a major public legal victory for the accountability architecture. A court telling Trump's OLC that its memo cannot stand even provisionally. The records remain intact. The evidentiary backbone of the open investigation survives. If denied, the records are at risk during the litigation period. The accountability investigations are compromised. The documentation of the second term's governance decisions begins to develop gaps. And every gap is a permanent gap. Destroyed records do not come back. The Nixon versus GSA precedent makes the ultimate legal outcome likely to favor the AHA on the merits. But the question the emergency injunction raises is whether the court acts fast enough to prevent harm during the time it takes to litigate. That specific question, not the ultimate legal outcome, but the speed of the judicial response, is what determines whether the evidentiary backbone of this accountability series survives intact. The records exist right now. The memo exists right now. The lawsuit exists right now. What happens next in the next days and weeks determines whether those records still exist when the accountability reckoning arrives. The records exist right now. The OLC memo exists right now. The lawsuit exists right now. And the thing about records is when they are gone, they are gone. The court can strike down the memo in 6 months. It cannot restore what was destroyed during those 6 months. That is why the AHA filed for an emergency injunction instead of standard litigation. That is why April 7th matters as the specific date. And that is why this lawsuit, drowned out by the Iran war noise and the 70-plus removal calls and the civilization will die tonight aftermath, may turn out to be the most consequential filing of the entire accountability period. Not because it is the loudest, because it is protecting the foundation that everything else depends on. The records are the receipts, and someone is trying to shred them. Stay with this one. I'm David Harper, and we'll be tracking every development as it comes. One more thing before you go, because this is the detail that reframes everything. The AHA is not just any organization. It is chartered by Congress. That means the United States Congress itself created this institution and authorized its specific mandate: preserve and promote historical scholarship, including the historical record of American governance. When Trump's OLC memo declares presidential records to be personal property, records that historians need to do the job Congress chartered them to do, the AHA's lawsuit is not an advocacy organization taking a political position. It is a congressionally authorized institution fulfilling a congressionally mandated purpose, suing to stop an executive branch action that directly obstructs that mandate. That is the specific institutional character of this legal challenge that makes it harder to dismiss as partisan than most accountability litigation. The AHA standing in court on this question is, in a meaningful sense, Congress's own institutional purpose being asserted against the executive branch's unilateral self-authorization. Nixon vs. GSA already resolved this. The Supreme Court in 1977 told Nixon that separation of powers does not give a president personal property rights over records created using government resources to document government actions. The AHA is bringing that 50-year-old ruling back to court because the OLC memo is making the same losing argument. The records exist right now. The memo exists right now. And what happens in the next days and weeks determines whether those records still exist when the accountability infrastructure needs them. That is the story, and it is the one worth watching. I'm David Harper. Stay with this one.